Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law Section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law, and casual listeners eager to educate themselves about the hottest debates in these fields. Each episode is presented by one of the specialty committees within the section. This episode is produced and co-hosted by the Advertising Disputes and Litigation Committee of the Antitrust Law Section. Today's episode is on the problem with pixels. There's a meme you may be familiar with that says, if you're not paying for the product, you are the product. It references the likelihood that if you're using a service or platform for free on the internet, the company behind it is probably making money off of your personal information. They may do this in a number of ways. They may collect your personal information and sell it to a third party. They may serve third-party ads to you while you're on their website. Or they may follow you around the internet, serving their own ads to you even when you're no longer on their website. One of the most successful monetization models of Web 2.0 has been targeted advertising. There's contextual advertising, which is based upon the website's content, and behavioral advertising, which is based on user behavior, and includes the creepier retargeting, where you go to one website and find yourself seeing an ad for something you looked at on a completely different website at a completely different time. And one of the ways they do it is through tracking technologies, such as software development kits, or SDKs, application program interfaces, or APIs, or pixels. Here's how these tracking technologies work. The website owner or email sender adds some code to their website or email. After you visit the website or open the email, the tracking technology then transmits information about what you did back to the ad tech company, which may combine it with other information associated with you to create profiles of where you go on the web, what you look at, and what you put in your shopping cart. The company whose website you were just on can follow you and hit you with an ad for the product you were just looking at. Other companies can also use that information. By knowing that you were just looking at product A, they can serve you an ad for very similar product B somewhere else. Some of the consumer discomfort with advertising technology stems from my generation and older being used to the anonymity of the mall. When you went into a mall, you could browse with the freedom of being nameless and faceless. In fact, the phrase just browsing became mutually agreed upon code language for leave me alone. You never would have expected the mall to rearrange itself around what it thought you wanted to see as soon as you walked in. There's also additional discomfort from not being able to see these technologies or what information about us they're collecting, who's looking at it, or how much of our personal information they have. And in the absence of transparency, seeing an ad for a product you were just looking at 10 minutes ago somewhere else can straddle a line between annoying and creepy. But is it really all that different from the types of advertising we've received for decades through traditional media such as newspaper, television, and radio? Marketing pioneer John Wanamaker once said, "Half of the money I spend on advertising is wasted. The trouble is, I don't know which half." Are the tech companies who have been frequently criticized for using these technologies simply better than old media at their own game? After all, what is the weekend section of a newspaper but a way to segregate an audience with desirable common characteristics and serve them with targeted advertising? In the absence of federal privacy legislation in the United States, there are a few hard stops on what and how much of your personal information can be collected through advertising technologies. One of those is Section 5 of the FTC Act, which prohibits unfair or deceptive acts or practices on the consumer protection side. Over the last few years, the FTC has been more aggressive in using its powers to crack down on the use of advertising technologies by websites through guidance and a series of investigations into health websites. What happened in those investigations and the consequences for companies using pixel technologies is the subject of today's episode. Joining me on the show today to discuss these issues are Michael Sherling. Michael is an attorney in the Federal Trade Commission's Division of Privacy and Identity Protection, where he focuses on protecting consumers from unfair or deceptive privacy and security practices. Welcome, Michael.
Thank you for having me.
Olivia Adendorff is a partner in the Dallas, Texas, and Washington, D.C. offices of the law firm Kirkland and Ellis. Her practice focuses on FTC consumer protection investigations and private class actions, which often involve data privacy issues. She represents a number of companies who are defending investigations or class actions related to pixel technologies. Welcome, Olivia.
Excited to be here.
Finally, Alan Butler is the Executive Director and President of the Electronic Privacy Information Center, or EPIC, a public interest research center located in Washington, D.C., focusing on, among other things, advocating for data protection and privacy laws. Alan has authored briefs on behalf of EPIC in a number of significant privacy cases. Welcome, Alan.
Glad to be here.
Michael, let's start with you. What are pixels?
So first, let me say that the views that I say here are my own and do not represent the views of the Federal Trade Commission or any particular commissioner. So tracking pixels they started out as tiny images embedded in websites that track user interactions with the web page, but have evolved into a wide variety of technologies, generally using HTML and JavaScript, that are embedded in web pages and emails, and really can look at, track, view every interaction that a user has with a web page. And they're a subset of larger, tracking technologies that include cookies, APIs, SDKs that can be embedded either in web pages or in apps and have similar functions across the internet.
Who offers pixels and how do they end up on websites?
Pixels are offered by a wide variety of players in the ad tech ecosystem. Many of the large social media companies that we're all familiar with use pixels to support their advertising. And then other companies that most people may not have heard of also have pixels that publishers embed in their websites to kind of do similar functions, assist in their own advertising. And when I say publishers here, I mean kind of the web page that the end user is interacting with. So that is, for example, CNN or the New York Times or Target, or really any web page that has advertising or has an interest in understanding how their users are interacting with the web page.
And at baseline, the reason is to make money, whether it's finding your customers and selling them the thing that they were looking at or collecting information and monetizing it. But oftentimes the companies that are hosting these websites don't have the technology. They need to access a third party's tracking technologies that they're incorporating as opposed to their own. It's just easier for them to do it that way.
That's correct. Generally, most websites that you visit won't have developed their own pixel or their own tracking technology. They rely on some third party, either through a service provider arrangement or through a data sharing or data disclosure arrangement where the third party is placing the pixel on their behalf or for the third party's own purposes.
Olivia, I brought up at the top a lot of the concerns that people have raised with pixels. How are these beneficial?
The value of pixels to website creators is clear. They've voted with their feet. Pixels are on almost every website on the internet. And I think we've talked a lot about marketing pixels, but I also want to highlight that pixels can be used just for basic analytics. Without pixels, website creators would not know how many people visited their website. They enable all kinds of analytics, including what parts of your websites attract the most interest, where do you lose your consumers in your purchase funnel, do they find checkout difficult and quit halfway, are there parts of your website that never get visited at all, and you find out that perhaps the links to them are broken. This use of pixels enables website creators to make their web pages better. They can fix and identify problems, and they can receive valuable feedback from visitors on what content is most useful. As a result, pixels and the data that they capture make the internet better for everyone, and this directly benefits the website users. As you've mentioned, pixels can obviously also be used to track users for marketing purposes. Someone visited your website in the last week but didn't make a purchase, you can try to reach those people with ads. While the plaintiffs' bar and regulators often act like marketing is a very nefarious purpose, it is actually beneficial to consumers and economically efficient to receive marketing messages that are tailored to your pre-existing interests. You can target me all day long with ads to attend a monster truck rally, but that would be a waste of your advertising dollars, increasing the cost of your ultimate product for consumers, and I would experience those ads as annoying clutter. But target me with suggested toys that I could have gotten my kids for Christmas, and I might find that quite useful.
Alan, why are pixels controversial?
Thanks, Anant. I think that ultimately, to your earlier point, tracking ads and the more sort of invasive the algorithms and systems behind them, on one level, I think consumers find creepy. And on a second level, I think raise more fundamental concerns about how the structure of our websites and apps and ecosystems might be fueling deeper social problems, or at least raising more deep-seated concerns that people have about the sort of control they have over their own identities and their own information. I think that there's a difference between using the tools of web analytics, which pixels are one, like Olivia explained, to understand and improve how websites function. It's very different. I think consumers recognize the difference, to take data about what people are doing on website A and B and C and D and use that to build a comprehensive profile and make inferences about those people's behavior or about their preferences, about their identity. If you dig down into the types of categories that the ad tech vendors use to tag and categorize people in these behavioral profiles, they can reveal disability information. They can reveal people's health information. They can reveal, and these are all inferences made about people that are used to target them with ads. So I think it goes a lot beyond just retargeting for an individual product. There's a deeper behavioral profiling going on based on people's holistic web browsing history that I think people find much more troubling.
Michael, can you tell us about the FTC's recent pixel settlements and the related guidance?
Sure. So over the past few years, the Federal Trade Commission has brought several cases involving website use of pixels that have transferred information unfairly and deceptively to third parties, generally for advertising purposes. So I will run through them. GoodRx in 2023 was a telehealth provider and drug discount provider that we allege transferred sensitive personal information, including health information, to third parties without consent and contrary to their representations. Similarly, BetterHelp, a mental health and telecounseling provider, used pixels, we allege, to transfer mental health information to third parties for advertising purposes. Premom, also called Easy Healthcare Corporation, was a fertility app that used SDKs and APIs to transfer health information to third parties for marketing purposes. And in 2024, our complaints against Cerebral and Monument alleged that Cerebral shared sensitive health information with third parties like LinkedIn, Snapchat, and TikTok, and Monument shared addiction treatment information similarly with third parties for advertising purposes. And each of those cases resulted in monetary settlement. So, it shows that the commission is serious about protecting consumers, especially where the publisher is transferring information, sensitive information, for advertising purposes, unfairly or deceptively.
So let's put this into context. What other enforcement and guidance has the FTC been taking and offering with respect to the collection of personal information online?
So these cases and others are in the context of the Federal Trade Commission looking at the collection, use, and disclosure of consumers' personal information generally for marketing purposes or for undisclosed purposes. And, in particular, in the case of sensitive information without the user consent. There are several other recent cases that have kind of demonstrated how downstream recipients of information collected via pixels use this information. So, for example, our cases against InMarket, Xmode, Mobilewalla all involve downstream recipients of data that were originally collected usually via Pixel or an SDK, and Many times that includes precise geolocation information. That information was transferred into the ad tech ecosystem via real-time bidding and advertising exchanges, and then collected by each of the recipients and used for profiling purposes, as Alan mentioned, or further sold to other data brokers without consumer knowledge and without consent.
Olivia, so now you have 5 settlements over a year and 2 months. You have the FTC staff report. You have joint guidance that's been issued by the FTC and Health and Human Services. Are the standards here clear?
Absolutely not. First of all, you just mentioned those are all settlements. The biggest problem in this space is that there are no clear rules, and the regulators and the plaintiffs' bar are largely having to make it up as they go along. FTC Commissioner Ferguson's concurring and dissenting statement in the Mobile Wallet settlement that Michael mentioned in early December highlighted this exact point with respect to determining what kinds of data are too sensitive for marketing purposes. He described deciding the definitive list of sensitive characteristics as a folly because he said, quote, "The list of things that can trigger each unique individual's trauma is endless." He said that any list would be either arbitrary or highly politicized, and that the current list is the, quote, "purely subjective creation of commission bureaucrats." The FTC to date has focused on things like health conditions, pregnancy, and religion. But for many people, their religion or their pregnancy, for example, is no secret at all. It might be right out there for everyone to see. So legislation could certainly help give companies fair warning in this space, but crafting such legislation is incredibly difficult for all the reasons I think that Commissioner Ferguson described, all the complexities in making these value judgments.
Alan, Epic has been advocating for a long time on data privacy and data protection issues. In your opinion, what's the right way forward here? Has the FTC provided sufficient guidance? Do we need legislation? Are you seeing proposed legislation or state laws that could help in this regard?
Well, I think that there's a lot of space for debate around middle ground solutions here. And in fact, the discussions in and around the proposed federal legislation, first in 2022, and then again earlier this year in 2024, I think really explored that. And the framework of the federal bills, this was the American Data Privacy Protection Act in 2022 and the American Privacy Rights Act in 2024, really focused on the rules for what types of processing, what processing purposes are allowed, again, beyond the processing that's necessary and proportionate to actually provide specific goods and services. So we think about advertising as a category of secondary processing, and the federal bill, for example, would have allowed non-sensitive data to be used, collected and used for advertising purposes, subject to the right of individuals to opt out, even potentially through some sort of a global baked-in opt-out system in a browser or app, but defined sensitive data to include data about these types of behavioral profiles. So there's a bunch of different dials that you can twist in that area of like what should the categories be of the type of data that are subject to a global opt-out or opt-in or are prohibited entirely, sort of the what's a green light, what's a yellow light, what's a red light, perhaps is one way to think about it. And that's, I think, there's a lot of space in there between the different proposals we've seen to discuss specific rules. When you compare that to a more sort of generalized reasonableness framework like we see in Europe that I think provides a bit less clarity and requires even longer to get to answers to some of these questions that we've seen.
I think one of the difficulty is that any solution or all the solutions we've talked about really put a lot of burden on the consumer, sort of an unrealistic burden, website by website. In the EU, we, notice and consent frameworks, and that's a lot of what the FTC and other regulators have looked at here in the United States. And the difficulty with that is when you notify consumers constantly on every website you visit, asking them to accept cookies and accept various settings, I think all of us ignore that. And, either we accept them or maybe we deny them across the board. But to say that we're making some kind of reasoned decision website by website is a legal fiction. And yet and even Lena Khan has challenged that and called that into question. So I think creative solutions here are needed, and I don't think an obvious one has presented itself yet.
Yeah, I think consent fatigue is a huge problem, and one of the major sort of weaknesses of any model linked so tightly to consent as many models have been. I do think that there are a lot of solutions that have been considered, will continue to be considered, but ultimately we have to decide whether our legal system is going to give people the capacity to decide they don't want to be tracked and behaviorally profiled based on everywhere they go on the internet. Either we do or we don't. We can talk about what the mechanism is for that to happen. But if we exist in a world where it is legal to track every website I go to and build a behavioral profile for whatever use you want to do, then there are entities online that are going to do that. And I think from our perspective, that's a problem.
So, personally, I would be in favor of federal legislation that does place more specifics in our federal privacy law, especially for general privacy and not sector-specific privacy. But I want to say that the Section 5 framework that we have does prohibit many of the practices that we've been talking about here. The Commission has alleged and has obtained settlements showing that tracking users' browser history across the internet is a deceptive and unfair practice. That was in the recent case of Avast, where a browser plugin tracked users' websites interactions and then sold that to third parties. So, we do have remedies here, and I don't think that they are confusing for businesses to implement. Businesses need to be thinking about what consumers reasonably expect their data to be used for, especially in the context of the disclosures that they're given, and not just in the privacy policy, but in prominent upfront disclosures. And they need to only use the data for the purposes that they disclose, and not unfairly to transfer it to third parties or for other purposes.
I think the tricky part about the unfairness standard is that it's very subjective in the application of the benefits, the analysis of the benefits. And as I mentioned at the beginning, I think there are real benefits to the economy as a whole and to consumers and businesses from some of these practices. And I think some of the harms can be a little overstated. At the end of the day, seeing advertising that is targeted to you, people may just say it's creepy. That's the common phrase, creepy. But is that a real harm? And I don't know that that's been sufficiently explored.
We're talking here about broad ad tech ecosystem. And I think that the uses for analytics probably don't present many of those harms. But the widespread collection of and profiling that Alan mentioned, and that the Commission is currently litigating in at least one context related to the sale of location information, does present some harms that federal courts have recognized. So I don't think that it's a either or proposition. It's a gradient, and a limited first-party use of data, with the website that you're interacting with, where you may understand that, sure, if Target wants to know kind of what I searched for and then ended up purchasing, I may think that's a reasonable use of my information. But if then that information is sold on to thousands of other companies with my precise geolocation information attached to it, that seems to be less intuitive from an end user perspective, and the harms can, multiply.
I just wanted to add that, I think it's important to differentiate when we talk about the benefits of some of these systems between those that actually require the type of longitudinal tracking of users across the internet from those that don't, right? It's not necessary to collect the type of behavioral browsing data across different websites and systems that we're talking about to serve ads, right? Ads can be served, as Anant mentioned at the top, through a lot of different mechanisms. They can be targeted through different mechanisms, including context, and also including the example Olivia gave, which retargeting is a specific visit of a specific website, then an ad sent to that person. A lot of those ads get retargeted via email, for example, but there could be other mechanisms. But that I do think is I draw a fundamental distinction between that and the type of cross-context behavioral advertising that involves building large longitudinal data sets about people's browsing habits over time, including particularly sensitive location information and other data like that can be used for other things. And I think it's about more than just being creepy. If we think about the broader social context here, there are people that are living in jurisdictions that are worried about being targeted by law enforcement for activity that in other parts of the country or 5 years ago was completely legal. And so I think that the world around us can change, and that data can really be dangerous sitting in anyone's hands, let alone the wrong hands.
I think there's also a rejoinder that if product advertising is so great, why not just let consumers choose to opt into it? If people find something online that they really like, they'll rush into it, hence the rush on Stanley tumblers. But we've been focusing a lot on consumers and individuals who go to these websites. Olivia, what's been the effect on business owners? Are you seeing more plaintiffs' cases as a result?
Absolutely. There's been an explosion of this kind of litigation. It's been a real concern for companies because it's been a little bit unpredictable what exactly they're going to take issue with. 2022 was the year that this really started, and we counted 140 suits that year. In 2023, that number jumped to 265, and there was hundreds more filed in 2024. The plaintiffs' bar is being very creative and trying to fit various website facts into a lot of different kinds of old state laws and common law theories, including state wiretapping statutes and common law invasion of privacy claims, and even really old-fashioned laws like pen register or trap and trace laws, which maybe a couple of years ago I'd never even heard of. And then there's also, more vanilla breach of contract claims based on website privacy policies. But the floodgates have definitely opened for attacks of all kinds on information that some might say is arguably sensitive, or even things like I saw one that was about a website for checking the weather. And, if someone knows what weather you checked, is that really sensitive or not at your zip code level? So that the companies are definitely concerned and are watching this space very closely.
This has been a great discussion. And when we were talking about solutions, Olivia, I'm sympathetic to what you're saying about how consumers get exhausted having to make decisions on every single website that they go to. Maybe the solution lies creatively somewhere in the middle, where the solution is in the browser. You plug in your privacy preferences and it interacts with websites for you in a way that preserves the level of privacy that you want, but also allows some of the benefits that you've been talking about. But these are ideas for companies and policymakers to pursue. In the meantime, what are some of the key takeaways here for practitioners? Olivia, let's start with you.
Well, the most important thing that businesses can do is to know what data they are sharing, who they're sharing it with, and why they are sharing it. And that is actually very difficult to do, particularly for startups that are using these kinds of products off the shelf. And sometimes the people building the website don't even have really advanced understanding of computer code to really be able to answer those questions. So that's the first step, and that's a very big step for a lot of companies. And then once you know what you're sharing, you can accurately describe it to consumers, and where necessary under the laws, you can obtain consent.
Alan?
Yeah, I think building off of what Olivia said, I think that most businesses are takers in this marketplace, where they're not building the tools that determine what data exactly gets collected and what happens with it up the chain if they're engaging with other vendors in this ecosystem. And I think those businesses and the practitioners representing them, it really behooves them to learn about the laws that are coming out and changing. And there's been a lot of change in the last 5 years, and to advocate for themselves and their users. I think that there are a lot of circumstances where it takes a business pushing back on a vendor up the chain and saying, do you really need to collect this much data? Or do you really need to collect location data that's this precise for this purpose? because the user doesn't have the ability to do that in this sort of chain of decision making. So I think that's really important.
And Michael, what are your takeaways for practitioners?
I echo what my esteemed panelists have said. I like to think of this all as data stewardship. And when a company is collecting their customers' information, they, just as Olivia said, should understand what data they're collecting, how they're using it, and how they're disclosing it. And there are real risks associated with the use of some of these advertising technologies. If the company maybe is in a sensitive business, direct to consumer health business, or collecting precise geolocation information, the use for undisclosed or unfair purposes, or the transfer of that information can subject them to Section 5 penalties, or potentially, monetary penalties or consumer redress. And, bidders are very interested in looking out for that.
Well, Olivia, Alan, Michael, thank you. This has been one of the best and clearest explanations of advertising technology and the issues surrounding them that I've heard. So thanks as well to the Advertising Disputes and Litigation Committee for putting this program together. To our listeners, be sure to subscribe on your podcast platform of choice, and we'll see you next time on Trust and Trade.